Good morning, everyone. My name is Tim Wyroni. I'm the symposium editor for George Mason Law Review. Welcome to the 26th Annual Antitrust Symposium here at Scalia Law. First, thank you to Professor Josh Wright, Judge Douglas Ginsburg, the Global Antitrust Institute, Amanda Osofsky-Hu, Daniel Tonsing, Judy Jin, our panelists, and everyone else whose hard work and patience made this event possible. Specifically, a shout out to NERA Economic Consulting, whose generous sponsorship made it possible for us to be here today. I'm thrilled to be in person for this event and to hear our panelists speak. At Scalia Law, we are fortunate to have unrivaled academic centers like the Global Antitrust Institute that give students opportunities to engage and work with leading legal scholars. It's an honor for the Law Review to partner with various centers on campus to plan our symposia and publish thought-provoking articles. If you have any questions or compliments about today's event, I look forward to hearing from you. If you have any complaints, there's a black box trash can out front where you can place those. Thank you for joining us today. I'm pleased to turn the mic over to Professor Wright to get started.
Good morning, everyone, and thank you for coming, especially of those of you who got here for early in the morning for the first panel. We are thrilled to be back in person and doing this, and grateful for your attendance. And as Tim said, especially grateful for our participants, the GAI staff, the Law Review staff, our sponsor, NERA. Tim sold the effort of the Law Review a little bit short. This is their symposium, and we help. But Tim and the Law Review did a wonderful job putting all the content you see here together. We helped a little bit around the edges and are especially grateful for Tim's efforts and the efforts of the Law Review putting this together today. But you're not here for me to do introductions. You're here for the panel. So let's get to the good stuff. Bruce, take it away. Thank you, guys.
All right. Thanks, Josh. I will be really short in introducing the panel. We've got a great panel, and the topic is antitrust and labor markets. I think there's been some interest in this topic, but we've got to my direct right Dennis Carlton. Dennis is, and I'm not being. I mean this seriously. Dennis is one of my favorite economists. Often when I think about writing something, I start looking to see who's written on it, the issue, and Dennis has already written the article. So he's made me a lot less productive. But we also have Derek Moore, a proud member of Lodestar Law and Economics. And when I was there, he was in the Office of Policy and Planning at the FTC. We have Eric Posner, who is the Kirkland & Ellis Distinguished Service Professor of Law and is just back from a stint at the DOJ Antitrust Division. And last but not least, Lauren Styro, who is the Managing Director, NERA Economic Consulting. When I jokingly said some people are paying attention, one of the things that has captured the attention of the GAI and is the recent FTC notice of proposed rulemaking to ban non-competes. But the concern about maybe not just labor markets, but monopsony power has been a growing concern both in the antitrust community and in economics. During my tenure as the director of the Bureau of Economics, my first conversation with the incoming chair, Joe Simons, was about monopsony. And little did I know that I'd still be doing this later. So I think what we're going to do is Dennis has a PowerPoint, and he's going to sort of talk about sort of the changing views of economists, especially labor economists, in thinking about sort of the frequency and incidence of monopsony power, and then we'll sort of go around to some of the issues about whether or not there's a difference between classical monopsony and bargaining, the implications for antitrust, and hopefully we'll get to the implications for things like merger analysis, and I will reserve some time to talk about the NPRM. So Dennis, why don't you take it away?
Okay, thank you. It's a pleasure to be here. I don't have a PowerPoint.
Oh, okay, that's good.
Because no one else does, so I didn't want to stand out. There's been a huge change in the views among labor economists about the prevalence of firm market power in the labor market. In the few minutes I have, I can't go through everything, but I would recommend there are some good review articles, David Card. There's a whole issue of the Journal of Human Resources devoted to monopsony, but it is a hot topic in labor these days. 20 years ago, the prevailing view was that most firms faced a very elastic supply curve for labor supplied to their firm. That means if you offered a wage rate that was below the competitive level, you would have a hard time keeping your workforce and getting new workers. Now, there were some exceptions that everybody sort of commonly recognized. The one-company town, a city with just a few hospitals that has employing nurses, professional athletes, but by and large, the view I told you was the prevailing one. I would say now the prevailing view is that most firms have at least some market power in the labor market, with the implication that perhaps, not necessarily, but perhaps, the wage rate is below the competitive level. There's a very close analogy to what happened in my field, industrial organization, say at least 40 years ago, where there was a recognition that every firm has some market power. How much depends. By the way, that doesn't mean that 40 years ago, as a result of this recognition, everybody said, let's use the antitrust laws to combat this market power. Sometimes the antitrust laws are appropriate and sometimes they're not. One frequent mistake that I'll mention is that in the case of simple, what's called classical monopsony, where you set a wage rate and see how many workers show up. If you have market power in that market, you will set a wage rate less than the competitive level. You will hire fewer workers. That means less output gets produced. That means a price is higher than it would otherwise be. That is bad for society. There's a frequent error in which people say, wage rate is being reduced. That's good because then we pass on. There's no pass on like that in classical monopsony. Now, in bargaining models, there can be, but it's important not to sort of fall into a trap that I just described. Well, what does this new view explain? This new view can explain what were otherwise puzzling features, that raising the minimum wage can sometimes increase employment, not decrease it, that there's an incentive for independent firms to have a no-poach agreement, and that there's an incentive for a firm to impose a non-compete, even for low-wage workers where there's no training involved. What about the quantitative evidence? And there has been a lot of quantitative studies, although not as many as I would like. There have been some estimates of supply curves to individual firms and show they're not completely flat, they're not completely elastic. There's been estimates of the effect of large, I underline the word large, very large mergers that have large effects in the labor market, and they do seem to have sometimes a depressing effect on wages, not on employment. And there have been estimates of what happens when you get rid of no-poach agreements, there have been a handful of studies. And there is mixed evidence of, and I'm sure we'll talk about it, what happens when you get rid of non-competes. What I want to end with is the following. It's important to understand what is the source of monopsony power, of market power on the labor side. Is it that there are just a few employment opportunities? Is it that there's poor information and high search costs? Or is it that there are market impediments to labor mobility? For example, you can't cross state lines if you're in a licensed industry so easily. Or that there are entry restrictions, as there are in some states. If you want to build a hospital facility, you need a certificate of need. So figuring out if market power on the labor side is a problem and then figuring out what to do with it is important. And in order to do that correctly, you need to know what's the source. My own view is the economic mechanisms in our antitrust laws are sufficiently flexible to deal with monopsony power, but let's not fall into the trap of saying just because there's market power in the labor market, I have to use the antitrust laws for something. I'll stop there.
All right, thanks, Dennis. Next up, I'm going to have Eric talk about, he has a great term for this, and he calls it the litigation gap. And so in monopsony, I have to say that during my time at the FTC, we did, they were marching orders, but we were very sensitive to let's find a monopsony case. And we had people looking, and we had a coal mine merger. And we just said, oh, this has to be it. And it turns out that there wasn't really any specialized assets or specialized skills that were required to work in the coal mine. You just needed to know how to drive a large vehicle. So we were far disappointed. But let's have Eric talk about sort of the implications of the new learning that Dennis discussed on antitrust.
Sure. Thank you, Bruce. And yes, I use this term litigation gap in research I've been doing, which explores much of what Dennis was just telling you about, this new academic research on anti-competitive behavior in labor markets. And the puzzle that I start off with is that this literature suggests that anti-competitive behavior in labor markets is quite common. And I'm going to go into a little bit more detail to avoid the accusation of falling into the trap that Dennis identified. But there's been very little litigation, which is not to say that there's no litigation. There's been labor market-related litigation for many, many decades. There's actually a Supreme Court case from 1927, which is a classic labor market case. It involved a bunch of ship owners who agreed through an agent to pay the same wages to sailors that they hired. So it was a wage-fixing agreement and a no-poach agreement. And the case went up to the Supreme Court, and the Supreme Court said the question was whether the antitrust laws apply to labor markets, and the Supreme Court said, yes, they do. So this question of whether the antitrust laws apply to labor markets was settled a century ago. It wasn't a complicated legal question because there's nothing in the statute that would suggest otherwise. And the cases ever since then, of course, have recognized that antitrust laws apply to labor markets. They're all the sports league cases that you may be familiar with and which Dennis mentioned. So, clearly the law applies to cases where employers fix wages or agree not, or divide labor markets, but there have been very few cases. And the cases that have occurred have always been these kind of weird cases like these sports league cases. So if you go back 10 or 20 years, you might have said, well, the reason why there's so many antitrust cases involving product markets or other output markets, but few involving labor markets, is that labor markets are competitive, whereas product markets are not always competitive. That was the conventional wisdom, as Dennis says. and that conventional wisdom has been overthrown. So now the new conventional wisdom is that like product markets, labor markets are not always competitive. Now, I want to say a little bit more about this academic research. Of course, it's like all academic research, it's subject to criticism. People have been challenging it, but some of it is really undeniable. So for example, there are a series of papers that use different data sets and methods, but they all find something very similar, which is really obvious once you think about it. If you look at the labor markets around the country, a huge fraction of them, there are very few employers competing for certain types of workers, specifically rural labor markets in small towns, suburban areas, and so forth. So there are lots and lots of areas in the United States where there might be a factory or some farms and some restaurants, some fast food restaurants. And so there's a population living there, but there are very few employers. And maybe there are a few people who will hire an accountant or a lawyer or a doctor. Maybe there's a hospital nearby, but there's really not much competition. Now these are classic concentrated markets. If you look in, of course, big cities, labor markets are much more competitive because there are often lots of employers competing to hire people with the same skills. But even in big cities, maybe outside Manhattan or downtown Chicago or other, really big, dense cities, if you look at highly specialized jobs, highly trained software engineers, pediatric oncologists, often they're just a very small number of employers who are competing for them. So there's actually a lot of markets where there's a high level of concentration. This means Dennis brought up this issue of what's the source of monopsony power. So just as in the case of product markets, it's true, and there's a lot of work on this, that a big source of monopsony power are government restrictions on people's behavior, search costs, and differentiation. But concentration is also a big source of market power, and that's what antitrust law can be helpful for, because of course when mergers take place in concentrated markets, that's where antitrust law has a role to play. When markets are concentrated, that's when collusion can be harmful. When markets are so concentrated that there's really, just a monopolist or a monopsonist in this case, then there's the concern that firm uses its market power, for example, by using non-competes to prevent entry. So there is a role for antitrust to play in those settings. Antitrust. There's been work, I wrote a paper with an economist named Suresh Naidu, which tries in a very back of the envelope sort of way to try to estimate, how much good can antitrust do, given that so much labor market power is due to these other sources. And the answer is, well, it can do a little, but it's not going to solve the whole problem. It can't really do much to deal with search costs. So one does have to be careful, as Dennis, I think, was emphasizing, not to overclaim the benefits of a more vigorous use of antitrust law. But I do want to say that there isn't any real reason to think that there ought to be a litigation gap. That if when you look at the cases, 95 or maybe 99% of them are product market cases, and very few are labor market cases. And further evidence for this is the fact that there's been a massive change over the last few years. So if you go back 20 years, there were the sports cases, NCAA cases and so forth, some National Football League cases and so forth, but very few cases in which employers were sued on antitrust grounds. Over the last 5 years or so, there have been quite a few, some of them brought by the government, including a number of criminal cases, as well as civil cases. There was the first real merger case, the Penguin Random House Simon & Schuster merger case. The FTC also filed a submission in a merger case where the FTC plausibly argued that a hospital merger in Texas would suppress the wages of medical professionals there. And then there's been a lot of private litigation recently and litigation brought by states involving, for example, these franchise no-poach agreements, and then just regular no-poach agreements between firms, wage-fixing agreements. All of these things have come out of the woodwork because people started looking for them. So it seems very likely that this type of anti-competitive behavior has been going on for a very long period of time. It's only recently that people have started looking for them and bringing these cases. And then there are the non-compete cases, but I think I'll stop here so that we'll talk about the FTC rule later. But there are also cases involving non-competes, which people increasingly are looking at as antitrust cases rather than just common law cases.
All right, thanks, Eric. I'm going to go next to Lauren. Dennis mentioned sort of, well, he called it simple monopoly, but I call it classical monopsony. And quite correctly stated that if there's a classical monopsony, in addition to monopsony, things are worse, right? Even under the consumer welfare standard, right? Downstream consumer prices are higher, output's less, the welfare loss is even bigger. And then you really sort of have this notion that the word monopsony means something more than classical monopsony these days, that includes at times what I call bargaining harms to sellers. There's a paper by Nancy Rose and Scott Hemphill. Can you sort of take us through, whether there's a distinction with respect to implications for antitrust between classical monopsony and bargaining? The use of the word monopsony to mean some kind of bargaining harm that's not necessarily classical monopsony.
Sure, I'd be happy to. It actually starts, if you could tilt that a little my way, picking up on some of the things that Dennis was saying. There's been a lot of research recently on this topic. It is a hot topic. There's been a lot of really good research. And one of the things that always catches my eye is in the introduction, they will, of course, tell you what monopsony is and start by talking about what monopoly is, and frequently have the phrase that monopsony is the mirror image. And I think that is wrong right out of the box. So monopoly, we've got a single buyer who has some pricing power, who can use their pricing power to raise the price, reduce output. There is deadweight loss, there is consumer harm. There is a whole lot of economic theory behind that, years and years of indicating that this is what the outcome that we're going to expect pretty much in any market where you've got a monopolist. A monopsonist, single buyer, with some power over the input price. So we've been talking about labor, so we think about the input price as a wage, but it could be any input. We care more, I think, just naturally when we are talking about people, are people being paid less? We probably don't care so much if it's negotiation over the raw materials cost. And so one of the assumptions that Dennis mentioned about classical monopsony is we would think if the monopsonist has power over the wage, can reduce the wage, then we make a big leap. Let's now say, okay, so then fewer people are employed so that there's less output in the end market and everybody is harmed. That in input markets is a really big leap. Even in labor markets, we don't know for across the board, do we have the same sort of an upward sloping labor supply curve, which matters for what the outcomes are. When we're talking about a firm with some sort of buyer power to negotiate the price that it's paying for inputs, we can't make the leap to say that if the input price goes down, output is going to go down. Because with a product market, when a firm changes the price, that is the price that consumers are seeing. When a firm is making something, it's using labor, it's using capital, it's using energy. It's got a range of ways to make that final product. And so the price of one of the inputs changing doesn't necessarily mean that we're getting a reduction in the final output. what we would think from just looking at theory of a firm. If their costs go down, the firm might produce more. There are more dynamics in a monopsony case because it has those, the inputs and the input prices matter differently for how then the firm reacts than when we're talking about an output, a product market where we've got a monopolist being the only seller of that product. I think one of the factors that matters here too is when we're focusing, when Eric mentioned that there's a role for antitrust and this type of, I think you called it anti-competitive behavior. When I, as an economist, hear anti-competitive behavior, I naturally think prices are going up, consumers are harmed. When we're talking about wages going down and workers being harmed, there's a tension. If the wages come down and so individual workers are now earning less, we've got two other possible effects to take into account. One, does that mean that prices have come down as well? I think Dennis said we don't get trickle through for wages, but that's something to be studied. And that's something to be studied on an individual basis for individual markets. But just consider the possibility. If wages come down, there's a possibility that prices come down. And now we've got a tension with the antitrust laws. Are we thinking about consumers or are we thinking about workers? And do we have a basis for caring about one more than the other? One other just thing that I think comes out of some of the academic literature, the quantitative literature, there are also competing outcomes. There's some ambiguous effect for welfare effects even in the labor market. So if we see that we've got things like non-compete agreements, no-poach agreements, and there's a measured reduction in wages, there is also, in some cases, an increase in the level of employment. So more people employed at a lower wage. So now who do we care about? Do we care about the people that were formerly unemployed and now receiving a wage, or do we care about the delta on the people that would have had a job anyway and are receiving a lower wage? And how do we care about the final product market where, just sort of the language of the antitrust laws, the language of what we're used to is consumers. Are consumers paying a higher price or a lower price? I will end actually, just so that you're not thinking I've lost the question completely, Bruce, on the bargaining models. Where I think that they fit in is on this idea of, do we actually have a reduction in employment? If you've got a monopsonist that's a wage setter and then people are choosing whether or not they're willing to work at that wage, maybe we see, in those models, we see a reduction in the amount employed. When we've got a bargaining model, the way that I think about that, we've got people that are going to negotiate some kind of an outcome, and who gets more of the gain from trade. And maybe it goes to the employer, maybe it goes to the physician or somebody that's got some recognizable skill. But if we are bargaining over the gains from trade, the final output is not going to change. It's just a division of what the rents are, what the excess profits are in that case. And so I think that is an important consideration for considering whether there is antitrust harm in the consumer sense, or whether there are harms in labor markets, and then which group do we care about the most for weighing all of the harms and all of the benefits.
All right, thanks, Lauren. Want to go to Derek? Let him get in here. So Dennis actually made a point that I always thought was one of the shocking things. I spent a whole bunch of time in a law school, and that makes you soft. And then I went to BE, and it really reminded me what economists do, and it's shocking. But one of the things is, from the time I last worked in an antitrust agency till when I returned, they've gone to the primary model is differentiated products, Bertrand, and as Dennis said, there's always sort of what economists think of as market power. Everybody has a downward sloping demand curves. The guppies are always positive, and that's all fine. Actually, Eric and Glenn Weil have this great paper, it's like all property is monopoly, right? Or what's the title? I always think of that article when I thought about what was going on in BE. And the real question, which Dennis suggested, is not whether there's market power defined as a downward sloping demand curve, but whether there was antitrust relevant market power. So, even if the supply elasticity of labor is not perfectly elastic, are there tools, or how would you address whether or not, some degree of market power is something that antitrust laws would be concerned with.
Thanks, Bruce. I think it's a challenging question, and I think it's a question that we can't really look to case law to help us think about, because as Eric mentioned, there is a litigation gap. We have many fewer cases that attempt to define labor markets, both in terms of their geographic scope, but also in terms of what you might view as the product analog to a labor market case. So I would call that an occupation market. And we don't really have a sense, particularly at the lower end of the wage scale, what jobs are substitutes for one another. I think the sports leagues cases illustrate this, because if you think about an average member of a professional sports league union, it's fairly easy, I think, to think that each athlete's best alternative is working in an occupation at a much lower wage. Not always the case, but particularly for players like NFL players or NBA players. And so that idea, at least for me, suggests that there is a relevant labor market for professional basketball players or professional football players. And that you can imagine a sports league having monopsony power, or even total monopsony power over those workers. As you go down the wage scale, and not necessarily, but as you get toward the bottom of it, I don't have intuition about what the available substitutes are for workers. And it could be rather narrow. I suspect that there are some workers out there who have extremely intense geographic preferences about their potential occupations. So there's a massive difference between a job that is 1 mile away from where you live and a job that's 3 or 4 miles away from where you live. And if you are thinking about drawing markets the way that we do in merger cases, using the 2010 merger guidelines, thinking about reasonable substitutability, it suggests to me that there's a tremendous amount of heterogeneity in terms of worker preferences that we need to look at in each individual case. And so it's difficult, I think, to draw broad conclusions, which sort of dovetails on a point that both Dennis and Eric made about the new economic research, and Dennis in particular talked about the older revolution in industrial organization economics. And much of the older work that I don't want to say was pushed aside, but is looked at differently today, was these cross-industry studies of market concentration, where economists used industry classification codes to draw product market boundaries. And as time went on, that work became less and less, or was viewed as less and less reliable, because we litigated antitrust cases that defined specific markets, and became rather clear that those industry classifications did not match antitrust relevant markets in any way. If you think about a case like FTC versus Staples, the idea that paper clips sold at Walmart didn't compete with paper clips sold at office supply superstores, that's the kind of thing that would never be shown in those industry classification codes. And so it became sort of obvious that that work wasn't measuring market power in relevant markets. We just don't have the same thing with labor markets, because there haven't been litigated cases. Some of the newer labor concentration work uses a similar methodology. They look at occupation codes, standard occupation codes in the census. And those codes were developed not with an eye towards thinking about antitrust relevant markets. And yet, we do not have litigated cases that tell us that certain occupations do or do not compete with one another from a very targeted antitrust perspective. And so it's hard to evaluate that research in the same way. We can't say that those codes simply do not match antitrust relevant occupation markets. So I'll just go ahead and stop there.
Oh, thanks, Derek. So let me move to mergers, maybe in a way that is somewhat seamless. One of the things that the FTC has done over, during this century is hospital mergers. I mean, I don't know how the clearance process works, but that's certainly something that gets cleared to the FTC. And in the late 90s and early 2000s, there was this, I think, 8 or 11 merger losing streak that the DOJ, the FTC, and the state of California had, where they would challenge hospital mergers and they would lose. And, one of the things that my colleague Tim Meares did was he put together a merger task force to try and figure out what was wrong. And they did some merger retrospectives, and they figured out that the Alzinga-Hogarty test and the critical loss test were not drawing the right antitrust markets. They were really broad. They were hundreds of miles long. And so one of the things that was interesting is, do we have any evidence on the labor side? And there's a terrific paper by Elena Prager and Matt Schmidt that is in the AER, I believe. If you look at that, they show evidence consistent with the evidence that Dennis talked about, where the effects were on skilled physicians, like skilled nurses and things like that. And they find that some mergers are associated, or we could say cause, but it's a causal design, wage stagnation for skilled positions at hospitals. But then you also look at sort of what kind of mergers in terms of sort of those occupations and geographic markets would cause this. And on the labor side, the measures, I mean, you're talking about Herfindahl's of, 6,000, 7,000 and large changes. And so the question is, maybe the litigation gap is because, these things like that would have been caught anyways, or, Prager and Smith's data was the 2000s, and so maybe this is just a hangover of the problems that the antitrust agencies had in winning those cases. But if there's a litigation gap in mergers, and there just hasn't been any action on that for a long time, are there any examples, and I'll just go to the panel, of cases where there has been a miss? Prager and Smith maybe, but I don't think those mergers would have. I mean, they were challenged then. They would probably be successfully challenged these days. I heard Nancy Rose say this. I won't take credit. She said, if you want us to do a monopsony case on every merger case, it's going to double the work, right? And a lot of cases, if you could solve the problem, both on the consumer side and on the labor side, by challenging on the labor side, why double your work?
That's not that's not right. I mean, when people do merger reviews, they look for the easiest. If they're skeptical about a merger, they're going to look for the market where it's easiest to challenge the merger. And the hospital mergers, I mean, look, all these mergers went through, right? It may very well have been easier to challenge the mergers based on their impact on labor markets rather than on product markets, because maybe people travel farther for medical care than nurses commute, for example. Or the hospitals offer much more complex types of medical care. They offer specialized medical care. There's emergency room services. You got to untangle all these different product markets and figure out which ones to look at. Whereas you have these very large labor markets, and a relatively small number of them, and the commuting is probably pretty similar, so your geographic markets are relatively easy to define. But beyond that, there are a huge number of industries where the labor markets are local and the product markets are national. And there are a bunch of papers. There's one by Ben Mellick and his co-authors. There's another one by Arnold, where they look at the manufacturing industries. And Ben Mellick's method, his empirical method is not as it's not as rigorous as Prager and Schmidt's. So I think people have more problems with whether the causal identification is good. But the basic point is very powerful, which is if you look at manufacturing markets, you're looking at, let's say, chicken processing plants or other food processing plants. You're looking at, factories that manufacture ball bearings or widgets or car parts or what have you. So you have a local labor market. You have people, maybe specialized mechanics, and the goods are sold nationally or internationally. And so and often you have clusters of these plants because of the nature of the supply chain. So often these plants are in rural areas. They have to be near certain types of farms, or they have to be near certain types of companies that supply inputs. So these mergers could have very significant impacts on labor markets. And you'll want to block the mergers if they cause significant wage pressure. And in fact, if you're the CEO of these companies, you're going to be tempted to merge for just these reasons. So I don't think now. I think extra work. I don't think these agencies. I don't think these agencies are stupid, that they're just going to mechanically do a lot of work where they think that the payoff is not going to be. That it's very unlikely that they're going to find something that's important, or that they're just redundantly doing something, so that if you can block a merger for multiple grounds, they're going to focus on the most important and not do unnecessary work. So I don't think that's a good reason to disregard markets. Or if you want, it would be a good reason to disregard product market effects of mergers and to focus on labor market effects instead.
Dennis?
Yeah, I just have a few comments. I agree with what Eric said. You have to trust the antitrust authorities to have some intelligence and not just create work, or I'd like to assume that. But in terms of following up on some of these studies, let me just make a few points. First, Derek correctly points out that in an industrial organization, people stopped running concentration on price. They just stopped that. That literature died. Unfortunately, you see that as some literature that is claiming monopsony in the labor area. That is not, to its credit, what the Prager paper does and Schmidt paper that both Bruce and Eric mentioned. But I want to say two things about that paper. The first is that it is studying the nurses as one of the groups it studied. As if you remember, my opening comment was that was well recognized even a long time ago, that was an area where you had to be concerned. I think it's interesting that the Prager paper and Schmidt paper find effects, but only for the very largest mergers. The typical change in their HHI for concentration in the labor market is 3,000. And only for highly specialized groups, not for just people working in the hospital. So I read that and say, gee, that's what I thought 20 years ago would happen for nurses. This new labor economics views might have suggested it happened for other people. It didn't. That's what I take. And they also show that there's a very small, they can't find an adverse employment effect. That's kind of interesting. That tells you that bargaining might matter. Now, they do find something that's quite interesting, and that is, and we didn't talk about this, when you bargain, the discussion so far has been the employer has all the market power and there's no market power on the side of the worker. Well, let's suppose workers are unionized. So now you're in a bargaining framework. One side has power, the other side has power. Does that make a difference to Prager and Schmidt? Yes. That's why they say, it's something going on about a market power here, and this can be countervailing power, and when you have bargaining, maybe that can make things better. So to follow up on something Lauren said, when you look at labor agreements, many of them are not of the sort, I'll yell out a wage and you just show up whenever you feel like for work. They're more often, here's the wage and here are the hours. Now, there's a very important point here when you set the price and the quantity. That's different than being on a supply curve. If you look at the product market, it's exactly the same. Our simple monopoly is you set a price, how many people buy. And as Lauren said, in the consumer market, maybe that's good. But maybe it's not so good. You go to Walgreens these days or CVS, they ask you, do you have a card? I'll give you a discount. So there's price discrimination going on there. What I think is nonlinear pricing, that complicates things. You should always have in the back of your mind, and this is what I learned from being in Chicago, whenever there's a deadweight loss, and this is what I teach my MBAs, or used to, when I taught micro, whenever you see a deadweight loss, that means there's an incentive for a smart entrepreneur to make some money if he can get rid of the deadweight loss. So you got to figure out, how do I get rid of it? I find the Schmidt paper, Prager and Schmidt paper convincing that there's market power for large mergers. The Arnold paper, I find a little less convincing. He focuses mainly on wages and manufacturing. But what he finds is, and I think it's a pretty good paper, for big changes, again, just like the Prager-Schmidt, for big changes in the HHI, wages go down by 2%. So, but he says even he prefers the Prager and Schmidt analysis of an individual industry, not going across industries. So I'm convinced there's some market power. Supply curves do slope upward, just like demand curves slope down. I'm not so convinced yet how important a problem it is, but I am convinced that if the Department of Justice or the FTC gets a merger, they'll be smart enough to figure out, gee, I should worry about this. And it seems to me they have the tools to worry about it.
All right. Lauren, do you want to?
Sure. I think just to echo something that maybe is a theme for me, so Eric, I hear what you are saying is that the agencies are not going to, of course, double their work. They're going to see where do we think the issue is. And so maybe it's a labor market, maybe it's a product market. I'm going to actually maybe just pass right on a question back to you, if that's okay. Do you see that whether there's a role for considering both? If you think that there's an impact in the labor market, should there also be an analysis of the product market so that we get more of a general equilibrium outcome, and we know what's happening both with prices of products and what's happening in the labor markets?
I think that's a trick question, isn't it? I'm tempted to reply with another question, which is.
You could then just pass it on.
No. No, I mean, as an academic, I think they should look at, both markets and do as comprehensive an analysis as they can. And, in reality, of course, they're going to start by looking at everything and narrow it down. They're pragmatic about this. But I do want to make a point about your point, which is that, there's potentially Nash bargaining on both sides. And one could just as easily say that we could look at product markets and ask, maybe a monopolist is raising prices and sharing the rents with workers. And maybe that's okay. But we don't, we don't do that. Like we don't, that's just not the tradition. So I don't see the argument for when we start talking about labor markets to start asking whether it's possible that that we're in a Nash bargaining situation and that there's actually an aggregate increase in social welfare once we look at everything that's going on, and not to bring an antitrust case on that basis, or that we should either do it in both cases or in neither case. So that would be just my reason. Maybe you think we should do it in both cases.
Well, I guess I'm in favor maybe of consistency.
Okay.
And so if we think that there is going to, in a labor market, if we think that there's going to be an outcome that's suppressing wages of a particular group of workers, if we thought about it, well, is there an analog to some other sort of raw material input? And if you've negotiated a lower price, I'm just thinking about a single party conduct, not an agreement to negotiate a lower price. But if you've negotiated a lower price, do you care about the bonus of the guy that's selling to you? Because his income probably went down through that same supply arrangement. I feel like there needs to be more of a unifying approach where we don't look at just individual markets individually. Sometimes in product markets, then maybe that makes a lot of sense to do that. But I feel like labor markets are always in the supply chain on the road to something else. And so I would think that we need to have some sort of a weighting mechanism for deciding which ones we care about more and why.
Well, economists have that. It's called welfare, right? It's called total welfare or allocative efficiency. I mean, I wasn't going to do this, but, I'll mention Josh's favorite case, Philadelphia National Bank, right? Maybe, and it'll get mentioned, next panel too. But, one of the many things, what's your title of your paper? Bad law, bad economics, good riddance or something? Yeah. One of the real things that they have this whole thing about out of market, ignoring out of market effects. And yeah, I mean, I think John Sellett has a paper which says, yeah, Philadelphia National Bank says you only, if it's just bargaining, so Walmart gets a lower price on Tide from P&G, and, there's harm to sellers, that's enough. And I think that's sort of, well, it's nuts. But, the way that I would sort of deal with that is just go to allocative efficiency, right? And, that's the way, we don't actually do weighting. I think we just do allocative efficiency.
Yeah, I agree with that 100%. One of the things in an airline merger that the Department of Justice routinely does, just think about an airline merger in which after the merger, I take a plane from New York to Boston and I now make it go from New York to Washington. So I've shifted capacity. Do I want to say that the Boston people have been harmed and therefore I should stop the merger, even though there are more people who are going to travel from New York to Washington? I mean, it's typical that they weigh consumer welfare. It seems to me in the labor context, again, let's step back. Labor is an input. There are a lot of inputs. Most B2B transactions can be viewed as input transactions. Nonlinear pricing, we know how to deal with those. Every vertical case, take the vertical case that the Department of Justice brought against AT&T Time Warner. When you have a vertical case, it's exactly how will the raising rivals cost on an input affect output prices, and how will the efficiency from the vertically merged firm wind up lowering output prices, who's going to win out. So we do these and what happens to total welfare. So we do this all the time. Now I understand under the antitrust laws, they try and compartmentalize, but I really, if there's one group that's harmed, that's enough to stop a case. That's really dangerous. In the labor context, I just want to make sure, what Lauren said, I think I would put a refinement on and agree with Bruce. I'd look at allocative efficiency, total welfare. But I'd weigh the harm in the labor market to the allocative harm in the labor market to any pro-competitive benefits if there are. I'm not sure I want to get into the business of rent transfers. That makes me really nervous. And that gets into issues having to do with, is the rent transfer going to a desirable person, say a poor person rather than a rich person? I'm going to count that differently. I think if the governments or the antitrust laws get into the business of redistributive weights, who really deserves the money more, we are just going to muck up antitrust. And my own view is we should focus on total welfare. Otherwise, I don't know what standard to apply. Now, that doesn't mean legislatively, you might want to follow public policies that, other than antitrust that favor one group over another. That's a different story. But to bring in redistributive issues to antitrust makes me very nervous, because I think that will make it so discretionary as to be unpredictable.
Dennis, you're saying it doesn't matter whether the Nash bargaining or classical monopsony is the correct description in a particular case? Because in both settings, there's the harm to and we're counting that harm and we're disregarding the effect on the consumers. Is that correct?
No, I wouldn't ever disregard the effect on consumers.
But that's cross-market.
Well, just think in a vertical case, you automatically take that into account in all these vertical merger cases, say the
Okay.
AT&T case that the Department of Justice brought. They automatically take that into account in
Okay,
their model.
and do you agree with
But-
Lauren then in the opposite direction then?
So in the opposite direction, if there's a bargaining outcome, say it expanded output, okay, and might have employed more people, you have to ask, is that better compared to the situation in which, some guy gets a higher wage, but you have fewer people? I could do that calculation. I could do a welfare calculation, and I could also figure out what effect that has on the exercise of market power in the downstream market. And it seems to me I should be trying to figure that out. Laborers are one group of, you can think of them as negative consumers because they're
Right,
supplying
right.
something. And
Yeah, they're
I would-
negative consumers.
Yeah,
basically. Yeah,
you
that's
know.
how I see it.
Yeah,
Yeah.
I think that's right. And I always like to come back to the airline mergers because I think that makes it the clearest. If I take over a multi-locational firm and I move some workers from, say, Boston to New York, so output goes down in one area and up in another, it seems to me that's not, but total output goes up because it's totally profitable. That seems to me sensible, and I don't want to attack that. That's my concern, if you compartmentalize things so much. Now, there have been attacks on airline mergers, not successful, that said, my city was harmed. I don't care that the rest of the country was benefited. My city was harmed. Stop the merger. And they've been unsuccessful.
All right, so I wanted to sort of actually spend some time on the FTC's NPRM on non-competes, and we have a half an hour that includes Q&A, which I do want to get to. So I guess I'll go to Derek. Away from economics, right? What are the dynamics? I mean, how do you see sort of the rulemaking playing out, and not just within the FTC? I think we all know that's going to happen there, but what's going to happen when it goes to the courts?
Well, I'll start first by apologizing to the three economists on the panel because I'm about to talk a little bit about civil procedure and what's likely to happen in litigation, so that you guys can follow on by talking about the evidence.
But we can learn.
Yeah. So.
Apologize to me also.
Okay, I apologize to you, and I'll wait to apologize to the audience. I think the first question is, what is a court challenge to the rule going to look like? Whatever the final rule says, whether it's a total ban or something else. And the first place to start is the FTC Act. The FTC Act provides a procedure for judicial review of cease and desist orders, which is primarily what we think of when we think of the FTC's law enforcement function. Section 6 of the FTC Act, specifically Section 6G, says that the FTC has the authority to make rules and regulations for carrying out the statute. Now, there is no judicial review provision for private entities to challenge rules that the FTC makes under Section 6G. I view that as a signal about whether the Congress in 1914 intended the FTC to have what you might call legislative rulemaking authority that creates legal obligations and duties on the one hand versus procedural rulemaking authority, things like scheduling briefs times for response and evidentiary burdens and things like that in the FTC's administrative process. So there is no judicial, and those sorts of procedural rules are not things that private entities are able to challenge in court. Those are things that an agency doesn't even have to go through the notice and comment process to do. They can just do them. And so if an entity is aggrieved by one of those rules, they can challenge it as part of challenging the FTC's cease and desist order. So there is sort of an open question about what process an entity would use or a group of entities would use to challenge the FTC's forthcoming non-compete rule. There is one case, 1973 in the DC Circuit, National Petroleum Refiners Association, where the DC Circuit held that the FTC did have substantive legislative rulemaking authority under the original FTC Act, Section 6G. And that case was brought in the district court in DC, and then it was appealed to the Court of Appeals, and the Supreme Court didn't take the case. So the DC Circuit's opinion from 1973 is the final opinion in that case. And an interesting tidbit about that case is that the litigants, it was an association, the National Petroleum Refiners Association, brought that case under the Administrative Procedure Act. So the court had subject matter jurisdiction to hear the case under the Administrative Procedure Act. But that process was totally foreclosed by the Supreme Court several years later. I believe Califano versus Sanders is the case, and it says the APA itself does not confer courts with subject matter jurisdiction. So to get a case into court, you have to use another statute. And I think the typical statute for this would be federal question jurisdiction 1331. And this sort of, at least for me, raises a question about the value of this, the practical value of this 1973 DC Circuit case. The entities who are likely to challenge the FTC's rule on whatever grounds, whether it be statutory authority grounds, constitutional grounds, whether the rule itself is arbitrary and capricious, are basically going to have a choice about where to file the case. And my conjecture is that their choice is likely to be somewhere other than the DC Circuit, just because the case would be bad for the challengers, and so they will go elsewhere. And they're likely to go probably to a friendly circuit, which we can all sort of have our own views about what circuits are more or less friendly. But my view is the practical value of that DC Circuit opinion is pretty low. It's not controlling precedent in any other circuit. And this will be, in effect, a question of statutory construction of first impression in whatever court decides it. And at least for me, that suggests that the probability of success as a pure legal matter, whether the FTC has the authority to do what it's trying to do, is rather low. And I'll stop there.
Well, since we have so many great economists on the panel, I guess I'll just throw out a question about the substance. The rulemaking is hundreds of pages long. I recently went through it in detail, and I really do thank the FTC for keeping all of us busy here. They are proposing a complete ban, and they have asked for alternatives of a partial ban. I think a lot of people think that they're going to ban low wage, but the current NPRM, the primary recommendation is to make non-competes an unfair method of competition. And I guess for the economists, is there evidence to do that? or do you have some view on, what the evidence is? Lauren, I don't know if you've looked at it or?
I'll start off and
Okay.
and then let others think through more but before they give their answers. So I looked at the paper that is cited on the FTC website, and I'd say, yeah, there is literature. People have done some real work looking at whether there is a measurable effect of non-compete agreements, so that if you reduce enforcement of them, there's a measured increase in wages that's fairly large. The fairly large actually catches my eye, that when the paper, I think, finds that there's that if there were reduced enforcement of non-compete agreements, wages, I think, across the country go up by 3 to 13% with an average of 8%. That finding is still in a world where fewer than half of the workers sign non-compete agreements, and a fairly significant percentage of people that have signed them aren't aware that they have signed them. So to me, I saw that the outcome, and I think it is a good piece of work, because what had to be done was look at how do you measure a reduction in enforcement. And so looking at a long time horizon, where were there laws that had changed the degree to which a firm might think that the non-compete agreement might be upheld? Where were there times maybe when they would be less confident that their agreement might be upheld? Some code all of those so that you've got some numerical measure of more enforcement versus less enforcement, run the model, and they come up with this outcome. But to me, the final numbers that they got sounded like the tail wagging the dog, and it's a pretty big dog that ended up getting wagged. So I haven't looked into the data, but that was sort of my immediate takeaway was, that's a little bit too big to be believable. There's been some follow-on literature as well that uses that same method, but maybe expands the number of outcomes that they're looking at, and so it doesn't look at just whether average wages are coming down, but the level of employment. And I mentioned this earlier in the session, that there's the countervailing finding that the average level of employment has gone up, and maybe innovation. And possibly quite narrowly defined, but innovation has also gone up. So there are these kind of different forces to take into account. But I think it's encouraging the level of scholarly research that went into the paper. Certainly there's going to be years and years now of other scholarly research, either finding the same result or finding different results. So it'll take some time, I think, to gel through. But I think encouraging that there really was deep thought, I thought, put into that paper. I do think that there's some of the results, I would say, are ambiguous, and just the size of it, I would want to think a little bit harder about whether that seems realistic given the prevalence or lack thereof.
Dennis, do you want to weigh in?
I'll say a few things. I think the evidence so far on the effect of non-competes, you would have to classify as mixed. One of the best papers is this paper by Starr and his co-authors, and it's in the Journal of Law and Economics, I'm proud to say, where I'm an editor. And what they find is that wages go up if you have a non-compete on average. But I think the most striking finding is that they go up if you've been told before you sign you have a non-compete. If you're, in a sense, told afterwards you have to sign the non-compete after you start working, there seems to be no effect. If you look at training, which is what most people or trained as most economists would think, well, non-competes must have something to do with training. The results are kind of interesting. They find, again, that training goes up with a non-compete. Again, if you're told beforehand. If not, there's no effect. But what Lauren mentioned about enforceability is also in their results, so that even though wages are going up, if you're in a state where they enforce with greater frequency non-competes, your wage goes down. So I would say that the evidence is kind of mixed on that from the Starr article. However, there have been other articles. So there's an older literature that shows that non-competes are frequently used for doctors, CEOs, and their wages go up with non-competes. On the other hand, people have studied what happened in Hawaii when Hawaii put a ban on non-competes among high-tech workers. Wages go up. And in Oregon, there's a study by Lipschitz and Starr, and wages go up when you ban them. So I would say the evidence is mixed. The surprising thing, at least to me, and I think to most economists, was the frequent use of non-competes for low-wage workers. You usually think of non-competes as trying to, preserve an incentive to train somebody. Well, are you really training these low-wage workers? Is a dishwasher being trained? I don't know. I don't think so. I wouldn't have guessed. So there must be some other reason. If you were going to go after it from the point of view of the FTC, and I'm no lawyer, and I don't intend to, give any legal opinions, but I was speaking to Alden about this earlier, Abbott, and it seems to me you could say there's an asymmetry of information. And rather than an antitrust violation, maybe it's worker fraud when you hire them, but I assume there are labor laws for such things. So I'm less certain about non-competes on the evidence. The difference between non-competes and no-poach is that a no-poach agreement is among horizontal competitors. A non-compete is a vertical agreement. And that seems to me an important distinction.
Eric, do you want to jump in?
Yeah, I'm more optimistic about the FTC rule, both on legal grounds and on the merits. So let me just back up a little bit on the sort of the theory for non-competes, and economists have been writing about this for a long time. There's a basic trade-off. So what employers or economists will say is that the basic benefit of a non-compete is that an employer may want to invest in a worker and worries that if they make a general investment in the worker's skills, the worker will then immediately quit, go to work for a competitor, and get a higher wage. So effectively, you're financing, your competitor's workforce, or the training of your competitor's workforce. So to protect yourself, you require your worker to hire a non-compete. And presumably, if the worker, knows what's going on, he or she will demand a higher wage. The cost, though, of a non-compete, it creates a negative externality because, of course, it may turn out that another employer can employ your worker more productively, and the non-compete blocks that from happening. And in theory, another employer could buy out the employee, but that would be very difficult. So it's ambiguous whether non-competes are good or bad from a social perspective. So there's actually a very large literature now. It has, I think, probably at least 20 papers. Evan Starr is the leading scholar here. He's written many of them, co-authored many of them. But other people have written as well. And I don't think the evidence is mixed. I should say there are different results, but the vast majority of papers are consistent in their findings, which is that when non-competes are used, wages go down. And now I should say that the studies are subject to all kinds of limitations. The way they usually do this is they look at the different levels of enforcement across the state. So all states, except for California and two others, regulate non-competes through the common law and through statutes. So many states say, all states actually regulate them, reflecting a common law tradition of treating them as restraints of trade. They're actually illegal unless they're narrowly drafted. This goes back to the 15th century or something like that. Excuse me. So this negative externality worry has always been around, but the states vary in their level of strictness. And so kind of crudely, the states have been coded to different levels of enforceability, and people look at outcomes across states and find that in states where enforceability is high, wages tend to be lower. That's a big part. And some of these studies are, they use shocks and so forth. The Hawaii study, for example, which Dennis mentions, is a pretty good study, looks at This is one of Starr's studies. It looks at tech workers. And so Hawaii decides one day we're going to block non-competes just for tech workers because we want them. And their wages go up, and they're able to compare, other types of workers who are sort of like workers who are not subject to this law, and the wages for the tech workers go up while the wages for the other people stay the same. And so, you can do better or worse types of studies that way. California famously does not enforce non-competes. They're illegal. So this, idea that non-competes are necessary for training, at least, anecdotally, doesn't seem that powerful given that California has the most innovative workforce in the world. There's this separate set of studies that Starr and others have produced where they survey workers and find out they often don't know about their non-competes. And that a huge number of workers who are completely unskilled and don't even are subject to non-competes, like I think 10% to 20% of unskilled workers don't even, are subject to them. So famously, a number of years ago, it was discovered that Jimmy John's sandwich makers, who Jimmy John's called sandwich artists, were subject to non-competes that prohibited them from working within a mile or two of any Jimmy John's in the country. Since there are thousands of Jimmy John's, that meant they basically could not work for any franchise, any sandwich franchise anywhere in the country, basically. And, they didn't know about it. The workers didn't know about it, which is kind of puzzling. But the story was that when they quit, or said they wanted to quit, their bosses would tell them that, well, okay, you can quit, but you can't work at another sandwich shop. So I think part of the motivation for this regulation is not really an antitrust concern, but just a kind of a consumer protection concern. Jimmy John's was sued by state attorneys general when this misconduct was discovered, but these laws are not always enforced. There's also a new paper by an economist named Lian Shi, which is coming out in Econometrica. She uses, I think, existing data, but a different model. And what's interesting about her paper is she tries to estimate the optimal non-compete and finds that from this kind of social perspective, it would only be a month long. And interestingly, this is true for highly skilled workers as well as for low skilled workers. And if you think about it, it is correct that most of these studies don't look at high skilled workers. But for reasons that Dennis and others have given before, non-competes are actually more of a concern for high skilled workers than for low skilled workers, because the high skilled workers, those are the people with who are actually the most productive people. So, if you have, let's say, a bank executive who's subject to a non-compete and is no longer able to work at his bank, he can't work, for a year or for 2 years, however long the non-compete is. And that productivity is just lost to society. Whereas if it's a sandwich worker, the lost productivity is not so great. So it may well be the case, although I agree, this is trickier, that the restriction on non-compete should be applied broadly and not just to lower income people. The legal side is very complicated, but I think we've heard enough about that, so I won't say more.
Just one. I will say more though. Just
Oh, you
one
say
quick
more.
quick follow up. Eric mentioned, at least as applied to low wage workers, the rationale for banning non-competes as applied to those workers sounds a little bit more like a consumer protection issue than an antitrust issue. And I'll just point out there is no ambiguity whatsoever that the FTC has the statutory authority to engage in consumer protection rulemaking. The processes are rather more cumbersome, but there is no viable argument that the FTC does not have the statutory authority to do it.
Yeah, let me say one more thing, which is at the intersection of the law and the economics. So there's a kind of a trend among the circuit courts, especially the DC Circuit, but also the Fifth Circuit, to require agencies to use cost-benefit analysis. Now, the FTC is an independent agency. It's a little unclear whether they have to do that. There's the document that they've issued includes a really sophisticated kind of cost-benefit analysis, which goes through this entire literature in a very good way. But I do think it could be improved. What's a little bit odd about it is that it focuses on earnings. It acknowledges that some of this, it does acknowledge the mixed aspect of the evidence, including some of the literature which shows that non-competes may improve investment. It does not quantify that, which it should. But it also doesn't really talk about the total benefit of the rule. If you believe the literature, the benefit of the rule is not just that it would increase earnings, it would increase output generally, because it would make available people and their skills and their productive capacity to employers who cannot currently, hire them because they're bound by these non-competes. And that, to the extent it's possible, should be estimated and put into quantified forms. And they can do that, but I think more work can be done to improve the chances that the regulation is approved by courts.
All right.
Yeah, could I just say
Oh,
one?
Yeah, sure, go ahead.
I agree mostly with everything Eric said. I think I have a slightly different view as to how strong the literature is on the adverse effects of non-competes for high-wage workers, because there is a literature that very highly paid executives get paid even more highly if it is a non-compete. But in terms of the point Eric made, which I think is a good one on the matching, that you're preventing someone who's really productive from moving, you should always ask yourself the question, why can't the private market somehow solve that? So there's a firm that wants to hire, Mr. X from his rival, and Mr. X has a non-compete. Why doesn't but Mr. X would be really productive at my firm. I can go to the firm and say, I'll buy him out. Well, why are you going to prevent me from buying him out? I'll pay for the training costs. And you should always ask yourself, are there any private market mechanisms that will get around this? I'm not saying that's a complete solution, especially at the low end, which I think is puzzling. And I would regard more as the use of non-compete at the low end as a consumer protection issue. But at the high end, when I'm talking about inefficiencies occurring, I want to know, what are the market mechanisms that I expect to emerge? Why haven't they emerged? And is that something that a government program could improve or make worse if there were an intervention?
All right, so the clock says 7:25, so I do want to save some time for audience questions. So we have any?
Sure. This will follow up on this question of the non-compete rule as a consumer protection matter. Who's the consumer here, and does that matter, right? I've not seen many consumer protection rules that are directed at an input. And I wonder if this is a hurdle to using the, MAGMOS rulemaking in this area.
On the margin, over and above the hurdles of doing MAGMOS FTA rulemaking? I don't know. Derek, do you want to?
I'll take a stab at that. So I do think it is a non-trivial hurdle. The only thing that I can point to is that the commission has pursued cases to protect workers under its Consumer Protection Authority under Section 5. I'm specifically thinking of a case against Uber. I believe the allegations were that Uber made deceptive claims related to how much drivers would be able to earn, and the commission, I think, reached a settlement in that case, so it wasn't litigated. But I take your point, Bilal, that the FTC Act does sound in terms of consumer protection, and you would be using a consumer protection statute to protect workers who aren't consumers, or at least not obviously consumers. Now, I think an economist would sort of view that distinction as rather silly, and I think it would be rather silly too, but this question sort of requires predicting how the courts are going to resolve that issue, and I just don't know. I think it's a hurdle, but I think it's a hurdle that can be passed.
Alex?
Question for Dennis on the total surplus standard. The NPRM, argues that, they seem to be arguing that a comprehensive ban on non-competes would increase total surplus on net. And they come up, with a number like $300 billion, which to Lauren's point, maybe that kind of is a little fishy. But suppose you believed that a ban on non-competes would increase total surplus on net. Should that always be the touchstone, or is there something else involved? There's an argument that the NPRM points to in the literature that there are negative externalities, and I think Eric pointed to that. So, the EPA will issue a ruling that says you got to stop putting mercury, into the water or whatever. Should total surplus always be the standard? We should be looking around for, as the FTC seems to want to do, where can we have sort of blanket rules that we, the FTC, think will increase total surplus?
Well, I think there are a lot of policy questions in which, for example, distributional issues matter. And I think there are a lot of policy questions in which you want to have a different value than total surplus. You might want to have a social safety net. You might want to provide certain types of insurance for the whole population, even if it would make, could lower output. It depends, though, and this is an important point, how you define output. So if we just define output as goods that are priced and don't pay any attention to people's mental health, to people's well-being, to people's safety, then you'll come up with an answer that, from society's point of view, you might say that's not a good answer. In applying the antitrust, and I believe a function of government should be to worry about those things. From an economic point of view, thinking about the antitrust laws, it makes me very nervous to think that I'm going to put a greater weight on a consumer who flies from Boston to New York than a consumer who flies from New York to Washington. I'm not saying you couldn't do that. I'm just saying I don't think that's the role of an antitrust authority. I would much prefer the antitrust authority to have a well-focused objective, and therefore businesses can predict what they're going to do. And if there's something else that's an objective, that can be either a different function of the agency or a different law. So consumer protection strikes me as something that I wouldn't want someone to be able to trick me as a consumer and me not know it, and me think I'm better off, and therefore, truthful information seems desirable.
Well, my hypothetical, I tried to exclude those issues. The NPRM doesn't argue for a disclosure rule. You have to tell the worker in advance that they're subject to an NPRM. It says ban it all. So my hypothetical, which may be unreasonable, is suppose you do an analysis and you find that a categorical ban on non-competes will increase total surplus on net. Is that sufficient to justify a ban?
If my option was either no ban or a ban, then from what you've said, it sounds like a ban is desirable. I would be very worried, though, that there is a better policy that would say, not going to ban it for everybody. There would be certain instances in which I see no justification for the ban, and that my policy option isn't do not, leave it alone, or just ban non-competes. It could be, I'll ban non-competes for this group, but not some other group, and that could be more welfare enhancing and raise total surplus more than what you've suggested in the total ban example. That would be, as an economist, how I would want to figure it out. I'd want to figure it out if the policy choice is to have a ban, how should I impose the ban? Where should I put it where I think the trade-off between my ability to figure out that it's harmful versus helpful is disappearing?
Okay. We have one more question?
Got one
Ken?
right here, too.
Oh, so we're out of time, unfortunately, but, yeah, quick.
I'll be quick. I want to shine a light on an angle that you didn't discuss. Non-competes are key in protecting trade secrets. And have there been any consideration on the effect that could be on, diluting trade secret protection, the effect on innovation and even national security, right? Thanks.
There's, we could do a whole panel on that, so. Kendall, do you want to?
Yes, I just had a quick question. When you were talking earlier about defining the relevant market, how does the increase of telework and remote work maybe complicate or affect defining the relevant geographic market?
That would make markets larger in many settings, which would reduce antitrust problems in many contexts. Unfortunately, mainly for higher income people who don't have to actually be in a particular physical place.
Yeah, it almost certainly increases the geographic market or widens the geographic market, but it also almost certainly varies among occupations. So it will likely affect some occupations much more than others.
I could just add one thing, too. I think it's a good question with the literature that we have been talking about. A lot of the outcomes, the data, ended in 2014 or certainly before the more recent experience. And I had a similar question of how relevant is the data and the outcomes really for what we're looking at now. So I think it's something that it definitely needs to be taken into consideration.
All right, well, let's thank the panel for a fantastic session. And we have a 20-minute break, and then we were back at 10:50 for panel 2 on updated merger guidelines.